Hello, friends. Welcome to the Entrant. We are back to you with the legal news highlights of this week. The news for the present video was referred from Law Times Journal, a one-stop destination for the Indian legal fraternity. Now, moving on to the weekly highlights, starting with first, Supreme Court said that Arnab will not be arrested till the case is in High Court, even if the order is adverse. The Supreme Court said that Republic TV editor Arnab Goswami will not be arrested till his case is pending before the High Court in terms of its November 11 order. The court also said that even if the order of High Court is adverse, he and his two other associates will be given protection for 4 more weeks. The court was announcing its verdict of granting bail to Arnab and said that the FIR against Arnab did not establish case of abetment to suicide prima facie. The court further said that the Bombay High Court failed to take view of the FIR and was at fault for not granting bail in the said FIR. Next, Supreme Court upholds the validity of Tribunal Rules 2020 with some modifications. The Supreme Court upheld the validity of Tribunal, Appellate Tribunal and other authorities, qualifications, experience and other conditions of service of members Rule 2020 with some modifications and ordered Constitution of National Tribunals Commission to supervise the appointments to and functioning of tribunals. As per the modifications, the Chief Justice of India or his nominee will have a casting vote while heading the committee. Next, Supreme Court takes suo moto cognizance on Rajkot Hospital fire tragedy. On Friday, the Supreme Court, while hearing a plea of fire tragedy at a Rajkot Hospital, Gujarat, in which 5 COVID-19 patients have died, has now taken suo moto cognizance of the shocking incident. After due hearing of the matter, the court ordered the central government to submit a report regarding the steps taken to avoid fire hazards. It also directed the Gujarat government to submit a report on Rajkot fire accident by Tuesday next week, that is 1st December 2020. Therefore, the court has adjourned the matter on December 1. Next, CJI SA Bobde said that pre-litigation mediation would reduce pendency of cases. Chief Justice of India SA Bobde, while celebrating Constitution of India, said that to reduce the pendency of cases, pre-mediation techniques should be used by litigants. He added that every litigation does not need all arguments to come to a logical conclusion courtroom. He said that due to COVID-19, we all adhere to a technology for conducting hearing through video conferencing, which we all are very much aware and are accustomed to. Next, Attorney General KK Venugopal proposes making of 4 benches of Court of Appeal. On the occasion of Constitution Day, November 26, a function was organized by the Apex Court. Speaking at the same, the Attorney General of India, KK Venugopal, suggested and proposed creation of 4 benches of Court of Appeal. The AG also cited research by Yale University and said that all of these cases filed at the Supreme Court, most of them are from North India. Next, Supreme Court allows 4 weeks to its Secretary General to file response. On Thursday, the Supreme Court has granted 4 weeks' time to its Secretary General to file reply affidavit on a petition seeking appointment of additional judges in Supreme Court under Article 128 of the Constitution of India. Justice A.S. Bopanna and Justice V. Ramasubramanian, while hearing a matter, has emphasized that it all appears very easy from the outside. We will see. We are not saying no to you, and has granted 4 weeks to file a reply affidavit. Next, Supreme Court asks whether Maharashtra Speaker be put to notice. Supreme Court bench of Chief Justice S.A. Bobde, Justice A.S. Bopanna and Justice V. Ramasubramanian took a serious view of the letter, which is considered as an attempt to forbid a citizen from approaching the top court in the course of exercising his fundamental rights under Article 32 of the Constitution. The court has asked whether a notice should be sent to the Maharashtra Speaker in contempt proceedings case who acted on the presiding officer's instructions. Next, Delhi High Court amendment made in 2018 to Prevention of Corruption Act does not have a retrospective effect. The High Court of Delhi has held that the 2018 amendment made to Prevention of Corruption Act does not have a retrospective effect. Before the amendment, Section 13(1)(d) of the Prevention of Corruption Act originally prosecuted the accused. The court opined that there is no impediment in hearing the criminal leave to appeal, since the offences in question are alleged to have been committed prior to the coming into force of the Prevention of Corruption Amendment Act 2018. Next, Center. Additional Sessions Judge has Human Rights Court in each Delhi District Court. On 24th November, the Lieutenant Governor of Delhi has designated the Court of Additional Sessions Judge 2 in each district as Human Rights Court. Presently, there are 11 judicial districts in Delhi state. Next, an adult woman is free to reside wherever she wishes and with whoever she wishes. Delhi High Court directs police to counsel the parties. Delhi High Court has provided relief to an adult woman who left her home to marry the man of her choice. The court noted that being a major, she has a free will to reside wherever she wants and with whomever she wishes. Next, Additional Advocate General of Kerala informs Kerala High Court Cabinet ready to withdraw Section 118A of Kerala Police Act. Section 118A, a provision was recently added to the Kerala Police Act by way of amendment. This provision was highly criticized by supporters of free speech, politicians in the opposition in Kerala. Many contended that it is arbitrary and curbs freedom of speech and even against the principles laid down by the Honorable Supreme Court in the case of Shreya Singhal versus Union of India. The submission was made by the Additional Advocate General of Kerala, stating that the government has decided to in fact take back the recent amendment. Next, IAF directed by Delhi High Court to pay arrears of pro rata pension within 12 weeks. The Delhi High Court bench of Justice Rajiv Sahai and Law and Justice Asha Menon, while hearing the bunch of pleas filed by 40 defense personnel, directed that each petitioner to pay arrears of pro rata pension from the date of discharge till the date of payment, and to, with effect from the month of March 2021, commence payment of future pro rata pension to each of the petitioners. If the arrears are not paid within the 12 weeks as aforesaid, the same will also carry an interest of 7% per annum from the expiry of 12 weeks till the date of payment. Next, refusal of marriage proposal cannot be grave and sudden provocation for murder. Karnataka High Court. The High Court of Karnataka on 20th November 2020 in the case of Vijay, that is Vijayendra versus the state of Karnataka, consisting of a double bench judge of Justices S. Sunil Dutt Yadav and P. Krishna Bhatt, rejected the defense of grave and sudden provocation taken by a jilted lover who murdered a girl on her refusal to accept his marriage proposal. The defense of grave and sudden provocation shall not avail an accused if the result of permitting such a defense is to dehumanize the person or victim, stultify her individual autonomy, agency and dignity, stated the Karnataka High Court. Next, Supreme Court asks state to file report on the treatment of COVID patients and their dead bodies. The Supreme Court resumed its hearing in the moto case for proper treatment of COVID-19 patients and dignified handling of dead bodies in hospitals. The three-judge bench of Justice Ashok Bhushan, R. Subhash Reddy and Amar Shah heard the case and has asked the states to file their current status report as well as compliance report. The case has been slated for next hearing on Friday. Last, life convict Perari Valan has no interest in further investigation. MDMA. In the Rajiv Gandhi assassination case, the CBI has informed the Supreme Court that the convict in the case of AG Perari Valan has nothing to do with the further investigation conducted in the case of its multidisciplinary monitoring agency into the larger conspiracy behind the assassination in 1991. The central agency was replying to the application filed by the mother of the petitioner, Perari Valan, to release him. Thanks a lot for watching. Hope you liked the video. If you liked the video, please do comment, share and subscribe to our channel, The Entrant, to keep yourself updated in this fast-paced competitive world. See you all next weekend. Till then, take care and be safe. Thank you.